Title 10, Crimes Against Property. Chapter 1, Robbery in General. Article 293. Who are guilty of robbery? Any person who, with intent to gain, shall take any personal property belonging to another by means of violence against or intimidation of any person, or using force upon anything, shall be guilty of robbery. Section 1. Robbery with violence against or intimidation of persons. Article 294. Robbery with violence against or intimidation of persons. Penalties. Any person guilty of robbery with the use of violence against or intimidation of any person shall suffer 1. The penalty of reclusion perpetua to death, when by reason or on occasion of the robbery the crime of homicide shall have been committed, or when the robbery shall have been accompanied by rape or intentional mutilation or arson. 2. The penalty of reclusion temporal in its medium period to reclusion perpetua, when or if by reason or on occasion of such robbery any of the physical injuries penalized in subdivision 1 of Article 263 shall have been inflicted. 3. The penalty of reclusion temporal, when by reason or on occasion of the robbery any of the physical injuries penalized in subdivision 2 of the article mentioned in the next preceding paragraph shall have been inflicted. 4. The penalty of prisión mayor in its maximum period to reclusion temporal in its medium period, if the violence or intimidation employed in the commission of the robbery shall have been carried to a degree clearly unnecessary for the commission of the crime, or when in the course of its execution the offender shall have inflicted upon any person not responsible for its commission any of the physical injuries covered by subdivisions 3 and 4 of said Article 263. 5. The penalty of prisión correccional in its maximum period to prisión mayor in its medium period in other cases, as amended by RA number 7659, December 13, 1993. Article 295. Robbery with physical injuries committed in an uninhabited place and by a band, or with the use of firearm on a street, road, or alley. If the offenses mentioned in subdivisions 3, 4, and 5 of the next preceding article shall have been committed in an uninhabited place, or by a band, or by attacking a moving train, streetcar, motor vehicle, or airship, or by entering the passengers' compartments on a train, or in any manner taking the passengers thereof by surprise in the respective conveyances, or on a street, road, highway, or alley, and the intimidation is made with the use of a firearm, the offender shall be punished by the maximum period of the proper penalties. In the same cases, the penalty next higher in degree shall be imposed upon the leader of the band. Article 296. Definition of a band and penalty incurred by the members thereof. When more than 3 armed malefactors take part in the commission of robbery, it shall be deemed to have been committed by a band. When any of the arms used in the commission of the offense be an unlicensed firearm, the penalty to be imposed upon all the malefactors shall be the maximum of the corresponding penalty provided by law, without prejudice to the criminal liability for illegal possession of such unlicensed firearm. Any member of a band who is present at the commission of a robbery by the band shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. Article 297. Attempted and frustrated robbery committed under certain circumstances. When by reason or on occasion of an attempted or frustrated robbery a homicide is committed, the person guilty of such offenses shall be punished by reclusion temporal in its maximum period to reclusion perpetua, unless the homicide committed shall deserve a higher penalty under the provisions of this code. Article 298. Execution of deeds by means of violence or intimidation. Any person who, with intent to defraud another, by means of violence or intimidation, shall compel him to sign, execute, or deliver any public instrument or document, shall be held guilty of robbery and punished by the penalties respectively prescribed in this chapter. Section 2. Robbery by the use of force upon things. Article 299. Robbery in an inhabited house or public building or edifice devoted to worship. Any armed person who shall commit robbery in an inhabited house or public building or edifice devoted to religious worship shall be punished by reclusion temporal if the value of the property taken shall exceed 50,000 pesos, and if a. The malefactors shall enter the house or building in which the robbery was committed by any of the following means. 1. Through an opening not intended for entrance or egress. 2. By breaking any wall, roof, or floor, or breaking any door or window. 3. By using false keys, pick locks, or similar tools. 4. By using any fictitious name or pretending the exercise of public authority. Or if b. The robbery be committed under any of the following circumstances. 1. By the breaking of doors, wardrobes, chests, or any other kind of locked or sealed furniture or receptacle. 2. By taking such furniture or objects away to be broken or forced open outside the place of the robbery. When the offenders do not carry arms, and the value of the property taken exceeds 50,000 pesos, the penalty next lower in degree shall be imposed. The same rule shall be applied when the offenders are armed, but the value of the property taken does not exceed 50,000 pesos. When said offenders do not carry arms and the value of the property taken does not exceed 50,000 pesos, they shall suffer the penalty prescribed in the two next preceding paragraphs in its minimum period. If the robbery be committed in one of the dependencies of uninhabited house, public building, or building dedicated to religious worship, the penalties next lower in degree than those prescribed in this article shall be imposed, as amended by RA number 10951, August 29, 2017. Article 300. Robbery in an inhabited place and by a band. The robbery mentioned in the next preceding article, if committed in an uninhabited place and by a band, shall be punished by the maximum period of the penalty provided therefor. Article 301. What is an inhabited house, public building, or building dedicated to religious worship and their dependencies? Inhabited house means any shelter, ship, or vessel constituting the dwelling of one or more persons, even though the inhabitants thereof shall temporarily be absent therefrom when the robbery is committed. All interior courts, corrals, warehouses, granaries, barns, coach houses, stables, or other departments or enclosed places contiguous to the building or edifice, having an interior entrance connected therewith, and which form part of the whole, shall be deep dependencies of an inhabited house, public building, or building dedicated to religious worship. Orchards and other lands used for cultivation or production are not included in the terms of the next preceding paragraph, even if close, contiguous to the building, and having direct connection therewith. The term public building includes every building owned by the government or belonging to a private person but used or rented by the government, although temporarily unoccupied by the same. Article 302. Robbery in an uninhabited place or in a private building. Any robbery committed in an uninhabited place or in a building other than those mentioned in the first paragraph of Article 299, if the value of the property taken exceeds 50,000 pesos, shall be punished by prisión correccional in its medium and maximum periods, provided that any of the following circumstances is present. 1. If the entrance has been effected through any opening not intended for entrance or egress. 2. If any wall, root floor, or outside door or window has been broken. 3. If the entrance has been effected through the use of false keys, picklocks, or other similar tools. 4. If any door, wardrobe, chest, or any sealed or closed furniture or receptacle has been broken. 5. If any closed or sealed receptacle, as mentioned in the preceding paragraph, has been removed, even if the same be broken open elsewhere. When the value of the property taken does not exceed 50,000 pesos, the penalty next lower in degree shall be imposed. In the cases specified in Articles 294, 295, 297, 299, 300, and 302 of this code, when the property taken is mail matter or large cattle, the offender shall suffer the penalties next higher in degree than those provided in said articles, as amended by RA number 10951, August 29, 2017. Article 303. Robbery of cereals, fruits, or firewood in an uninhabited place or private building. In the cases enumerated in Articles 299 and 302, when the robbery consists in the taking of cereals, fruits, or firewood, the culprit shall suffer the penalty next lower in degree than that prescribed in said articles. Article 304. Possession of picklocks or similar tools. Any person who shall, without lawful cause, have in his possession picklocks or similar tools specially adapted to the commission of the crime of robbery, shall be punished by arresto mayor in its maximum period, to prisión correccional in its minimum period. The same penalty shall be imposed under any person who shall make such tools. If the offender be a locksmith, he shall suffer the penalty of prisión correccional in its medium and maximum periods. Article 305. False keys. The term false keys shall be deemed to include 1. The tools mentioned in the next preceding article. 2. Genuine keys stolen from the owner. 3. Any keys other than those intended by the owner for use in the lock forcibly opened by the offender. Chapter 2. Brigandage. Article 306. Who are brigands? Penalty. When more than three armed persons form a band of robbers for the purpose of committing robbery in the highway, or kidnapping persons for the purpose of extortion, or to obtain ransom, or for any other purpose to be attained by means of force and violence, they shall be deemed highway robbers or brigands. Persons found guilty of this offense shall be punished by prisión mayor in its medium period to reclusion temporal in its minimum period, if the act or acts committed by them are not punishable by higher penalties, in which case they shall suffer such high penalties. If any of the arms carried by any of said persons be an unlicensed firearm, it shall be presumed that said persons are highway robbers or brigands, and in case of conviction, the penalty shall be imposed in the maximum period, as amended by RA number 12, September 5, 1946. Article 307. Aiding and abetting a band of brigands. Any person knowingly and in any manner aiding, abetting, or protecting a band of brigands, as described in the next preceding article, or giving them information of the movements of the police or other peace officers of the government or of the forces of the United States Army, when the latter are acting in aid of the government, or acquiring or receiving the property taken by such brigands, shall be punished by prisión correccional in its medium period to prisión mayor in its minimum period. It shall be presumed that the person performing any of the acts provided in this article has performed them knowingly, unless the contrary is proven. Chapter 3. Theft. Article 308. Who are liable for theft? Theft is committed by any person who, with intent to gain, but without violence against or intimidation of persons, nor force upon things, shall take personal property of another without the latter's consent. Theft is likewise committed by any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. Any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or objects of the damage caused by him. And 3. Any person who shall enter an enclosed estate or a field where trespass is forbidden, or which belongs to another, and without consent of its owner, shall hunt or fish upon the same, or shall gather fruits, cereals, or other forest or farm products. Article 309. Penalties. Any person guilty of theft shall be punished by 1. The penalty of prisión mayor in its minimum and medium periods, if the value of the thing stolen is more than 1,200,000 pesos, but does not exceed 2,200,000 pesos. But if the value of the thing stolen exceeds the latter amount, the penalty shall be the maximum period of the one prescribed in this paragraph, and 1 year for each additional 1,000,000 pesos. But the total of the penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed and for the purpose of the other provisions of this code, the penalty shall be termed prisión mayor or reclusion temporal as the case may be. 2. The penalty of prisión correccional in its medium and maximum periods, if the value of the thing stolen is more than 600,000 pesos, but does not exceed 1,200,000 pesos. 3. The penalty of prisión correccional in its minimum and medium periods, if the value of the property stolen is more than 20,000 pesos, but does not exceed 600,000 pesos. 4. Arresto mayor in its medium period to prisión correccional in its minimum period, if the value of the property stolen is over 5,000 pesos but does not exceed 20,000 pesos. 5. Arresto mayor to its full extent, if such value is over 500 pesos, but does not exceed 5,000 pesos. 6. Arresto mayor in its minimum and medium periods, if such value does not exceed 500 pesos. 7. Arresto menor or a fine not exceeding 20,000 pesos, if the theft is committed under the circumstances enumerated in paragraph 3 of the next preceding article and the value of the thing stolen does not exceed 500 pesos. If such value exceeds said amount, the provisions of any of the 5 preceding subdivisions shall be made applicable. 8. Arresto menor in its minimum period, or a fine of not exceeding 5,000 pesos, when the value of the thing stolen is not over 500 pesos, and the offender shall have acted under the impulse of hunger, poverty, or the difficulty of earning a livelihood for the support of himself or his family, as amended by RA number 10951, August 29, 2017. Article 310. Qualified theft. The crime of theft shall be punished by the penalties next higher by 2 degrees than those respectively specified in the next preceding articles, if committed by a domestic servant or with grave abuse of confidence, or if the property stolen is motor vehicle, mail matter, or large cattle, or consists of coconuts taken from the premises of the plantation, or fish taken from a fish pond or fishery, or if the property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance, as amended by RA number 120 and Batas Pambansa bilang 71, May 1, 1980. Article 311. Theft of the property of the National Library and National Museum. If the property stolen be any property of the National Library or the National Museum, the penalty shall be arresto mayor, or a fine ranging from 40,000 pesos to 100,000 pesos, or both, unless a higher penalty should be provided under other provisions of this code, in which case the offender shall be punished by such higher penalty, as amended by RA number 10951, August 29, 2017. Chapter 4, Usurpation. Article 312. Occupation of real property or usurpation of real rights in property. Any person who, by means of violence against or intimidation of persons, shall take possession of any real property, or shall usurp any real rights in property belonging to another, in addition to the penalty incurred for the acts of violence executed by him, shall be punished by a fine from 50 to 100 per centum of the gain which he shall have obtained, but not less than 15,000 pesos. If the value of the gain cannot be ascertained, a fine from 40,000 pesos to 100,000 pesos shall be imposed, as amended by RA number 10951, August 29, 2017. Article 313. Altering boundaries or landmarks. Any person who shall alter the boundary marks or monuments of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same, shall be punished by arresto menor, or a fine not exceeding 20,000 pesos, or both, as amended by RA number 10951, August 29, 2017. Chapter 5, Culpable Insolvency. Article 314. Fraudulent Insolvency. Any person who shall abscond with his property to the prejudice of his creditors shall suffer the penalty of prisión mayor if he be a merchant, and the penalty of prisión correccional in its maximum period to prisión mayor in its medium period if he be not a merchant. Chapter 6, Swindling and Other Deceits. Article 315. Swindling or estafa. Any person who shall defraud another by any of the means mentioned herein below shall be punished by: first, the penalty of prisión correccional in its maximum period to prisión mayor in its minimum period if the amount of the fraud is over 2,400,000 pesos but does not exceed 4,400,000 pesos, and if such amount exceeds the latter sum, the penalty provided in this paragraph shall be imposed in its maximum period, adding 1 year for each additional 2,000,000 pesos, but the total penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed, and for the purpose of the other provisions of this code, the penalty shall be termed prisión mayor or reclusión temporal as the case may be. Second, the penalty of prisión correccional in its minimum and medium periods, if the amount of the fraud is over 1,200,000 pesos, but does not exceed 2,400,000 pesos. Third, the penalty of arresto mayor in its maximum period to prisión correccional in its minimum period, if such amount is over 40,000 pesos, but does not exceed 1,200,000 pesos. Fourth, by arresto mayor in its medium and maximum periods, if such amount does not exceed 40,000 pesos, provided that in the four cases mentioned, the fraud be committed by any of the following means: 1. With unfaithfulness or abuse of confidence, namely, a. By altering the substance, quantity, or quality of anything of value, which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. B. By misappropriating or converting to the prejudice of another,
money, goods, or any other personal property received by the offender in trust or on commission or for administration or under any other obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond, or by denying having received such money, goods, or other property. C. By taking undue advantage of the signature of the offended party in blank, and by writing any document above such signature in blank to the prejudice of the offended party or any third person. Number 2, by means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. A. By using fictitious name or falsely pretending to possess power, influence, qualifications, property, credit, agency, business, or imaginary transactions, or by means of other similar deceits. B. By altering the quality, fineness, or weight of anything pertaining to his art or business. C. By pretending to have bribed any government employee without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. D. By post dating a check or issuing a check in payment of an obligation when the offender had no funds in the bank, or his funds deposited therein were not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank, and or the payee or holder that said check has been dishonored for lack or insufficiency of funds, shall be prima facie evidence of deceit constituting false pretense or fraudulent act. Any person who shall defraud another by means of false pretenses or fraudulent acts as defined in paragraph 2d hereof shall be punished by: First, the penalty of reclusion temporal in its maximum period if the amount of fraud is over 4,400,000 pesos but does not exceed 8,800,000 pesos. If the amount exceeds the latter, the penalty shall be reclusion perpetua. Second, the penalty of reclusion temporal in its minimum and medium periods if the amount of the fraud is over 2,400,000 pesos, but does not exceed 4,400,000 pesos. Third, the penalty of prisión mayor in its maximum period if the amount of the fraud is over 1,200,000 pesos but does not exceed 2,400,000 pesos. Fourth, the penalty of prisión mayor in its medium period if such amount is over 40,000 pesos but does not exceed 1,200,000 pesos. And fifth, by prisión mayor in its minimum period, if such amount does not exceed 40,000 pesos, through any of the following fraudulent means: A. By inducing another, by means of deceit, to sign any document. B. By resorting to some fraudulent practice to ensure success in a gambling game. C. By removing, concealing, or destroying in whole or in part any court record, office files, document, or any other papers, as amended by RA number 10951, August 29, 2017. Article 316. Other forms of swindling. The penalty of arresto mayor in its minimum and medium periods, and a fine of not less than the value of the damage caused, and not more than 3 times such value, shall be imposed upon: 1. Any person who, pretending to be the owner of any real property, shall convey, sell, encumber, or mortgage the same. 2. Any person who, knowing that real property is encumbered, shall dispose of the same, although such encumbrance be not recorded. 3. The owner of any personal property who shall wrongfully take it from its lawful possessor, to the prejudice of the latter or any third person. 4. Any person who, to the prejudice of another, shall execute any fictitious contract. 5. Any person who shall accept any compensation given him under the belief that it was in payment of services rendered or labor performed by him, when in fact he did not actually perform such services or labor. 6. Any person who, while being a surety in a bond given in a criminal or civil action, without express authority from the court, or before the cancellation of his bond, or before being relieved from the obligation contracted by him, shall sell, mortgage, or in any other manner encumber the real property or properties with which he guaranteed the fulfillment of such obligation. Article 317. Swindling a minor. Any person who, taking advantage of the inexperience or emotions or feelings of a minor to his detriment, shall induce him to assume any obligation or to give any release or execute a transfer of any property right in consideration of some loan of money, credit, or other personal property, whether the loan clearly appears in the document or is shown in any other form, shall suffer the penalty of arresto mayor and a fine of a sum ranging from 10 to 50% of the value of the obligation contracted by the minor. Article 318. Other deceits. The penalty of arresto mayor and the fine of not less than the amount of the damage caused, and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arresto mayor, or a fine not exceeding 40,000 pesos, as amended by RA number 10951, August 29, 2017. Chapter 7. Chattel Mortgage. Article 319. Removal, sale, or pledge of mortgaged property. The penalty of arresto mayor or a fine amounting to twice the value of the property shall be imposed upon 1. Any person who shall knowingly remove any personal property mortgaged under the chattel mortgage law to any province or city other than the one in which it was located at the time of the execution of the mortgage, without the written consent of the mortgagee or his executors, administrators, or assigns. 2. Any mortgager who shall sell or pledge any personal property already pledged, or any part thereof, under the terms of the chattel mortgage law, without the consent of the mortgagee, written on the back of the mortgage, and noted on the record thereof in the office of the Register of Deeds of the province where such property is located. Chapter 8. Arson and other crimes involving destructions. Article 320. Destructive arson. The penalty of reclusion perpetua to death shall be imposed upon any person who shall burn 1. One or more buildings or edifices consequent to one single act of burning, or as a result of simultaneous burnings, or committed on several or different occasions. 2. Any building of public or private ownership devoted to the public in general, or where people usually gather or congregate for a definite purpose, such as, but not limited to, official governmental function or business, private transaction, commerce, trade workshop, meetings and conferences, or merely incidental to a definite purpose, such as, but not limited to, hotels, motels, transient dwellings, public conveyance, stops, or terminals, regardless of whether the offender had knowledge that there are persons in said building or edifice at the time it is set on fire, and regardless also of whether the building is actually inhabited or not. 3. Any train or locomotive, ship, or vessel airship or airplane devoted to transport or conveyance or for public use, entertainment, or leisure. 4. Any building, factory, warehouse, installation, and any appurtenance thereto, which are devoted to the service of public utilities. Any building, the burning of which is for the purpose of concealing or destroying evidence for another violation of law, or for the purpose of concealing bankruptcy or defrauding creditors, or to collect from insurance. Irrespective of the application of the above enumerated qualifying circumstances, the penalty of reclusion perpetua to death shall likewise be imposed when the arson is perpetrated or committed by two or more persons or by a group of persons, regardless of whether their purpose is merely to burn or destroy the building, or the burning merely constitutes an overt act in the commission or another violation of law. The penalty of reclusion perpetua to death shall also be imposed upon any person who shall burn 1. Any arsenal, shipyard, storehouse, or military powder or fireworks factory, ordnance, storehouse, archives, or general museum of the government. 2. In an inhabited place, any storehouse or factory of inflammable or explosive materials. If, as a consequence of the commission of any of the acts penalized under this article, death results, the mandatory penalty of death shall be imposed, as amended by RA number 7659, December 13, 1993. Article 324. Crimes involving destruction. Any person who shall cause destruction by means of explosion, discharge of electric current, inundation, sinking or stranding of a vessel, intentional damaging of the engine of said vessel, taking up the rails from a railway truck, maliciously changing railway signals for the safety of moving trains, destroying telegraph wires and telegraph posts, or those of any other system, and in general by using any other agency or means of destruction as effective as those above enumerated, shall be punished by reclusion temporal if the commission has endangered the safety of any person. Otherwise, the penalty of prisión mayor shall be imposed. PD 1613 repealed Articles 321, 322, 323, 325 to 326 of the RPC. Chapter 9. Malicious Mischief. Article 327. Who are liable for malicious mischief? Any person who shall deliberately cause to the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Article 328. Special cases of malicious mischief. Any person who shall cause damage to obstruct the performance of public functions, or using any poisonous or corrosive substance, or spreading any infection or contagion among cattle, or who causes damage to the property of the National Museum or National Library, or to any archive or registry, waterworks, road, promenade, or any other thing used in common by the public, shall be punished 1. By prisión correccional in its minimum and medium periods, if the value of the damage costs exceeds 200,000 pesos. 2. By arresto mayor, if such value does not exceed the above mentioned amount, but is over 40,000 pesos. And 3. By arresto menor, if such value does not exceed 40,000 pesos, as amended by RA number 10951, August 29, 2017. Article 329. Other mischiefs. The mischiefs not included in the next preceding article shall be punished 1. By arresto mayor and its medium and maximum periods, if the value of the damage costs exceeds 200,000 pesos. 2. By arresto mayor and its minimum and medium periods, if such value is over 40,000 pesos but does not exceed 200,000 pesos. And 3. By arresto menor or a fine of not less than the value of the damage cost and not more than 40,000 pesos if the amount involved does not exceed 40,000 pesos or cannot be estimated. as amended by RA number 10951, August 29, 2017. Article 330. Damage and obstruction to means of communication. The penalty of prisión correccional in its medium and maximum periods shall be imposed upon any person who shall damage any railway, telegraph, or telephone lines. If the damage shall result in any derailment of cars, collision, or other accident, the penalty of prisión mayor shall be imposed, without prejudice to the criminal liability of the offender for the other consequences of his criminal act. For the purpose of the provisions of this article, the electric wires, traction cables, signal system, and other things pertaining to railways shall be deemed to constitute an integral part of a railway system. Article 331. Destroying or damaging statues, public monuments, or paintings. Any person who shall destroy or damage statues or any other useful or ornamental public monument shall suffer the penalty of arresto mayor in its medium period to prisión correccional in its minimum period. Any person who shall destroy or damage any useful or ornamental painting of a public nature shall suffer the penalty of arresto menor, or a fine not exceeding 40,000 pesos, or both, such fine and imprisonment in the discretion of the court, as amended by RA number 10951, August 29, 2017. Chapter 10. Exemption from criminal liability in crimes against property. Article 332. Persons exempt from criminal liability. No criminal, but only civil liability, shall result from the commission of the crime of theft, swindling, or other malicious mischief committed or caused mutually by the following persons: 1. Spouses, ascendants, and descendants or relatives by affinity in the same line. 2. The widowed spouse with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of another, and 3. Brothers and sisters, and brothers-in-law and sisters-in-law, if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of a crime. This is the end of Title 10.